My name is Claire Provost, and I'm a journalist with the Centre for Investigative Journalism in London, with also a long-standing interest in many of the issues that we'll discuss and debate today.
Good afternoon. Thank you very much for this opportunity. I'd like to thank Mr. Schlegelmilch for taking the time to participate in this event, and certainly like to thank the organizers. I will be focusing on the most recent proposed version of foreign investment protection that's emanated from the European Commission in the last few weeks. And if you could start the PowerPoint slide. What I'll do is This is an outline of concerns that I have had about the foreign investment protection provisions going back some time. And I always refer back to these core concerns when I evaluate the latest emanation of a proposal. And if you could please go to the next slide. So I'm going to move fairly quickly through each of the concerns, and I'd be happy to elaborate on any details you'd like to explore further, for example, in questions and answer, or that Mr. Schlegelmilch would like to explore further. The first point I'd highlight is a concern about the risk to democratic accountability and regulatory powers that is posed by these foreign investment protection systems. And very briefly, here's the nuts and bolts, the core elements of that concern. We're allowing claims by foreign investors in response to general laws and general regulations. And there are many ISDS cases that involve challenges to general laws and general regulations and are not simply specific to one story of a foreign investor. In turn, there's an uncertain financial risk that is created by the foreign investment protection system for governments and for legislatures when they're thinking about new decisions. It's the way I usually use the metaphor of the price tag. A government may be considering new legislation, but ISDS creates a new price tag for the legislation, and when the government looks at the price tag to see how much it will cost, the price tag says to be determined in a few years by a group of arbitrators. But by the point they determine the price, there's no opportunity to pull back from the decision. So I just worry about the impact of that kind of financial liability, that kind of risk in governmental and legislative decision making. And I also link to that, obviously, in turn, there is the tool that ISDS provides to lobbyists, to lawyers for large companies to behind the scenes go and meet with government officials and pressure them because of this potent tool that only they have in their arsenal of lobbying tools. So if we could perhaps move to the next the next slide. The next slide reacts to this first area of concern in light of the most recent proposals that have come from the European Commission. And I should first of all recognize there are positive steps that have been taken. I think the most significant is moving statement on the right to regulate out of the preamble, which is where it was put in the CETA text, into the substantive chapter itself. That is a positive step, but with that step, in my view, very unfortunately, what's happened is lurking in the details of the language, there are these catches, more provocatively, you could call them a kind of time bomb that will, possibly blow up the right to regulate somewhere down the road when the language is interpreted. Okay. So that's one specific point related to the latest proposals, which I can elaborate on in more detail if anyone would like me to, but I don't want to dwell on that for too long. Simply highlight some of the aspects that I don't see, but which are certainly possible and I think reasonable in the latest proposals. One being a simple preclusion on the review of general laws and general regulations. Another would be a cap on monetary awards that would make the foreign investment protection available for smaller size companies, but would not make it such a powerful lobbying tool for the biggest economic actors. There's also concerns that I have about these are general concerns about ISDS and the foreign investment protection system, which are still live in the most recent proposals, which is the pressures that are created for governments to enter into confidential settlements that involve matters of very serious public importance, such as changes to regulatory decisions that certainly affect the public and payment of public funds, potentially very large amounts of public funds. I think that kind of incentivization and pressuring on governments is an unfortunate outcome of ISDS, but it's certainly very much possible and even institutionalized in the latest and earlier presentations of the proposals that have come from the European Commission. So if we could move to the next slide, please. Okay, now if you can skip the next few slides. Okay, so these are some details. I can always return to them. It just comes from the text. Okay, so keep going, keep going. There's a few slides of text. I got a little carried away with the text last night. So, okay, then we're going to get to the second main flaw. Okay, and this is a flaw on which there have been steps that have been taken, and I want to acknowledge that there have been some positive steps taken, and I was actually enthused about it when I first saw the presentation. But when I looked at the legal text, I have to say my enthusiasm was dampened significantly. I say that as someone who, for many years, has called for an international investment court as a way to fix the existing system as it's applied primarily to developing and transition countries at the moment. But the main concern here is that ISDS, investor-state dispute settlement, involves a transfer of public powers from elected legislatures and independent courts and judges to arbitrators who are not elected and they're not independent. And this concern arises because of the lack of institutional safeguards of judicial independence in ISDS, the financial reliance of the arbitrators on prospective claimants and on executive officials, widespread conflicts of interest, apparent conflicts of interest that arise from the dual roles of arbitrators. Sometimes people talk about the gravy train for lawyers because of just the sheer amounts of money that are being earned. You know, in a single case, arbitrators billing over $2 million. I mean, it really is a very rich system. Okay, so if we can just move to the next slide. So first I want to acknowledge there are positive steps that the European Commission has taken, and the two I would single out is the shift to public appointment of, I'm still going to call them arbitrators, but arbitrators to a list on a tribunal. And the second is a process of normally random assignment of persons on the list to cases. It's not always random, but in general it's a system of random assignment, and I certainly applaud those steps. But there are other steps that I think would need to be taken before we could validly use words like judge and court. The metaphor I use is, you know, I can call myself a judge. I can say, please don't call me Mr. I'd like to be referred to as a judge, and maybe you would call me that, or it would be up to you. I can call my house a court, but to qualify as a judge or a court, I think all of the normal institutional safeguards of independence must be present. And if they are not all present, you know, you may have parts of a car, but the car is still not going to drive. Okay, it's still not really a car. So I'll just get a little bit specific here. So there is this requirement for public appointment of what the Commission calls judges, but there's still a link between and it's a link between quite lucrative remuneration and the frequency of claims that are brought by foreign investors alone. So there's still that dependence on prospective claimants. And there's still a link between remuneration and the length of the case, because the so-called judges will be paid a daily rate, quite a generous daily rate, rather than being paid a set salary. And it's typical for judges to be paid set salaries, and that's part of their package of independence features. There's also something that I find quite worrying, because I'm always alert to areas where I think the ISDS arbitration industry may have had influence on a government proposal. And where I'm concerned here, there's a clause on ethics that precludes the so-called judges from also being counsel in an investment case, an investment dispute, an ISDS dispute somewhere else under another treaty. But there's no preclusion on them also being an arbitrator. There's also no preclusion on them being a witness, being an expert, and I think that's an incomplete list. And that all of the conflicts of interest that affect arbitrators, we're all aware of, many people are aware of and have caused such public concern, many of those have the potential of being shifted right into this new system if you have someone working as an arbitrator and sitting as one of these so-called judges. There's also language on the eligibility of persons who can be appointed to the new tribunal. And I think there's some wording there that makes it too easy for non-judges to make it on the list. Okay? There's also just a basic reliance still on the old ISDS rules. The old arbitration rules of ICSID, UNCITRAL are still the basis for the procedure at this new quasi-judicial and pseudo-arbitration tribunal. And the way a court would normally work, there's a court and the court has its own rules and controls the rules, and those rules are designed for these kinds of public law disputes. Okay. And so I think to sum this up, the main concern I have is that whereas I would like to see judicial process replace ISDS, now I see a judicial process, at least partial steps towards a judicial process, being used to justify a massive expansion of ISDS beyond relations preliminary, beyond the circumstances of developing and transition countries, to cover the majority of developed countries too. So if we could go on to the next flaw, please. The next slide. Now we skip that one. Okay, this is, no, skip that one, please. Okay, so the third concern, general concern I've had is underlying the Commission's proposals is a blanket rejection of domestic courts as unreliable for foreign investors. So what we see is the exceptional removal of the customary duty of an individual claimant to go to a country's domestic courts first before seeking an international remedy. That duty to exhaust local remedy is a quite complex role, but a fundamentally important role in my view, and particularly difficult to justify when we're dealing with countries that have among the most reliable and mature court systems in the world. Related to this, we have quite a long and tortured history of ISDS arbitrators not respecting contractually agreed forums. This point quickly gets very detailed, so I don't want to dwell on it, but it actually points to not simply a too quick systematic rejection of the courts as a whole, but an unwarranted interference in the marketplace of contractual relationships. I'm also, maybe I'm going to skip the next 2 points because they really follow from these other points. A large part of the explosion of ISDS litigation in the last 15 years is linked to these 2 earlier points. Okay. So if we could go to the next slide. How does the Commission's proposal respond to this? In my view, it essentially fails to respond because it continues to not require foreign investors to simply to show before their claim can proceed that going to the domestic courts would be unreasonable or obviously futile. That's all the duty to exhaust local remedies requires. You can't say automatically that those domestic courts wouldn't offer me a satisfactory remedy to whatever problems I've had in the country. In the past, this lack of a duty to exhaust local remedies, to me, has been justified on very dubious grounds. There's often the proponents of the ISDS model point to 1 or 2 cases where they say a foreign investor in another country was mistreated. That's why we need ISDS. 2 cases that have been referred to are Lowen versus United States and Abitibi-Bowater versus Canada. I'll say in general now, I certainly do not find those cases, from what I know about them, convincing as a reason to conclude that somehow U.S. or Canadian courts are systematically, or even in those cases, not sufficient to provide adequate protections. Those cases have, in my view, been badly misrepresented, but it takes 10, 15 minutes to discuss each one, so I'm not going to dwell on them. I'll simply say what we would really need is evidence of systematic failings of U.S. and Canadian courts to justify the absence of a duty to exhaust local remedies in the TTIP or the CETA. And I have not seen really any serious evidence presented of those kinds of systematic failings to justify that policy decision. Okay, if we could move to the next slide. And this is the fourth and last concern I'm going to highlight. This is the general concern about how foreign investment protection, it privileges foreign investors over everyone else because it gives them unique and special access to public money. They have access to public money to compensate them for risks of operating in a country, generally risks of politics, risks of democracy, risks of regulation, which is not available to anyone else. So we might think of that in effect as a kind of subsidy for foreign investors alone that's paid by the public. Now, whenever one is calling for a subsidy for any group, the onus is on that person to show why the subsidy would benefit, not the person subsidized, everyone would like to have a subsidy, would benefit the public. And that's really the missing piece I've seen in the argument for ISDS going back a number of years. I don't see the case for why the public benefits more than it loses as a result of commitments to ISDS in the context of the CETA, in the context of the TTIP in particular. So there are various benefits that come for foreign investors in the ISDS model. Exclusive access to the proceedings, the ability to circumvent contractually agreed forums, as I mentioned, special access to public compensation. So are those concerns addressed in the latest reform proposals? If you could please move to the next slide. Here I see it actually worsening the situation because it's consolidating and expanding these privileges available to foreign investors. There's no provision for actionable foreign investor responsibilities alongside the rights and privileges that are laid out. Extraordinarily powerful rights and privileges, by the way, from the point of view of international law. But from the point of view of international law, the metaphor I use is foreign investors get a battleship, and victims of human rights abuses and environmental degradation and so on are rowing in a boat. Okay, that's the degree of the disparity, in my view, in the potency and enforceability of foreign investor rights and protections compared to everyone else in international law at a general level. Okay. There's another aspects I've indicated. Okay, so there are some steps taken in the Commission's latest proposals to give greater participatory rights to affected third parties. I think there's a positive element in that step, but it clearly doesn't go far enough because it doesn't give what any affected party should have, which is a right of full standing in a proceeding that affects their interests. Very basic right of procedural fairness. If a proceeding affects your legal interests, you're entitled to full standing in the process. And in this circumstance, there's an opportunity to get participation, but that's limited to making a statement to the tribunal. It doesn't include access to all of the documentation in the proceeding and so on. So that's why I'm still concerned about the lack of access of affected third parties. There's a lot of discussion in the European context about small and medium-sized enterprises. My short answer on this point, or my short concern on this point is, if the problem is that small and medium-sized enterprises need protections abroad, well, we could limit ISDS to those companies. Actually, even better, we could take a portion of the money spent on ISDS, mainly on lawyers and arbitrators, put it into an insurance fund, and make it available at relatively low cost to the most deserving small and medium-sized investors. That would be a much more efficient use of the money to address that problem, in my view. So if there's a problem for small and medium-sized investors, I don't see ISDS as the most obvious solution. And in fact, I've been working on some data to look at this question, and from what I see, if you look at the amounts of compensation ordered in ISDS, success rates in ISDS, this is really about protecting the largest companies. And by that I mean companies with over $10 billion in annual revenue. Okay, if we could move to the next slide. Yeah, okay, actually, no, we can skip that slide. I'll just sum up, yeah. Is it time? Yeah. Okay, so I want to stress again, I don't want to be mean, okay? I don't want to be, in English we would say, Debbie Downer, okay? All negative. I mean, I do acknowledge there are positive steps, but for me, as I've indicated, the four main concerns I've been expressing for a number of years, two of them are essentially fully outstanding or worsened. Two of them, there are limited steps that have been taken, some significant steps, but I'm afraid I don't think they go far enough to describe this as a fixed system as opposed to a flawed system in the way we've come to understand ISDS. Thank you very much.
Great, thank you. So now we can pass on to Rupert. I know there's a lot to respond to in Gus's presentation. Just to say quickly, I mean, one of the things that I would quite like to hear a response to is this basic question of what the public interest is in having a system like this, if it is a reformed system or otherwise. And also, I don't know if you can give us any sense of the internal debate when discussing and thinking through what kind of reforms could be possible. Did some people want to go further in some reforms and others not? Are there some things that Gus mentioned that are just politically infeasible?
Okay, thanks. Thanks for inviting me, and I'm very pleased to be here to try to contribute to this debate, which I think is very useful because, as you are all aware, we've been, I think, dealing with this issue now for 2 years with a huge public consultation, with a lot of input from all of you, and I think for now, at least we have some sort of intermediate result. And this result that Gus has commented on actually went online in its final version just 2 or 3 hours ago. Those of you who have linked into the DG Trade website will have seen that we have made public the formal proposal for negotiations with the United States. It looks pretty much like the one that Gus has based his presentation on. There are some tweaks also on the ethics question, which I think was just mentioned. But I'm quite happy to actually announce that we have now formalized, also presented to the parliamentarians, or MEPs, these proposals. And I would like to step back before we go into all these details, which are a lawyer's dream, but which of course have a lot of, and I don't want to deny that, have a lot of impact on what this proposal actually means and doesn't mean. I'd like to step back a little bit, because what are our options? We are trying with the best possible means in the Commission to reform this system. And we would be extremely happy if, although the critical voices in the room and on the podium and elsewhere would actually support us for one simple political reason. If this thing fails, what will happen is that you will have the TPP, which has just been concluded with a pretty much old style, not completely old style investment rules, which will be very influential in Asia. You have the 3,000 treaties which are out there, which will not be just cancelled just because we would like that to happen, or anyone would like that to happen. And you have a situation where all these cases that we sometimes talk about, and you know what the Vattenfall, the Philip Morris, whatever the case is, they are based on the unreformed system. And I'd like to show you that what we're doing here in the reform is actually the solution. The solution is not to shoot down a proposal which was built, which we tried to construct in the best possible public interest, and we are public officials, we are not representing any particular company, large or small, and then see whether we can work on that, because I will have to answer the question, of course, why we're doing it in the first place. Why don't we just junk the whole thing? And I think there are reasons which we would like to discuss, and which I think are also good reasons. If you look at the economic situation and the dependency of Europe on the international economic order to be legally bound and not a sort of Wild West or Wild East. So having said this, I think I'd like to just make that point because We are really trying very hard to go from a situation which we all thought is not satisfactory into something. It will never be perfect. I'm never going to please, or we are never going to please the perfect models that we can write upon or think about. But I think the glass for us, or at least, is certainly more than half full after the last discussions. And let me tell you why, and I will interweave a little bit what we just heard and try to react to these things, but also point out the improvements that we have really thought the new proposals have brought, starting with the very important point of transparency already in CETA. It hasn't been mentioned here, but much of the uneasiness comes from the fact that these proceedings in the past were not public. That has completely changed. I think we have a very, very open system now, actually more open than many domestic legal systems, to be quite honest. And that, I think, is my first point, where I think this should be recognized. If we don't get this, ongoing cases will not be transparent. Even the Commission has sometimes problems to find out what is happening in some of these intra-EU BIT cases which are now ongoing. Now, the first main point from Gus is there is a real risk price tag in legislation. I don't want to rehash the argument, even though there are some of the cases getting or going after a general law. Most of the cases are individual acts of governments. Okay, that's an academic point, but it's true. The more important point is that the proposal that we have put out is trying to address the issue, because there is unprecedented language there on public policy objectives and regulation in the public policy objective to be shielded from any attacks. And you can see it, for those who want to crawl through the text, you can see it in the article on the right to regulate, where it says nothing in this agreement shall affect the right to regulate for public purposes. And as you can see it in the indirect expropriation article, where it's also made clear you cannot just claim a law affects you. So I would take issue with the fact that this is about shielding profits of people. It is about investment protection. It's not about profits. It's about the core substance of the investment. And here, again, I want to step back a little bit and say it's not that unusual that states get sued. Actually, it's one of the great things that the citizens of Europe and the world have actually attained over the 2 last centuries. You can sue the state and you're not at the mercy of the state. This is where this idea actually comes from. It doesn't come from giving big or small corporations a right. There are thousands of cases, and thanks God, where you can sue, where citizens sue the state on data privacy and other things. I think that should not be in question, and the fact that we also have a system here should be put in context. The cases, some of the cases that we discuss, domestic proceedings are ongoing. The big case on energy, the shutdown of atomic energy in Germany, there is a case now in front of the Constitutional Court in parallel, and we might have to discuss whether parallelism is a good thing or not. But there, actually, in these domestic proceedings, the law is challenged. It's not just about damages, it's about challenging the law, which actually investor to state or the investment court system does not do directly. It's about damages, yes, and that can be painful, but it will never force a state to change the law, unlike domestic procedures, which are very often exactly that. They want to change the law. So you can say this is a cynical argument, whether you pay or whether you have to repeal your law. I think for lawmakers it does make a difference. It does make a difference that laws cannot as such be challenged. And the evidence is, I think, or will be, that if you have the right protection, and this is why I go on this right to regulate clauses in our new proposals, I think there will be very, very, very little risk that the general legislation is challenged. We have numerous cases where implementation also of European laws is challenged in our member states, because implementation, you have officials on the ground to do things. But the general law, I think, is pretty safe in our new proposal. And the idea that there is a challenge, that there are backroom deals where people threaten governments, well, I mean, I don't think the government will be less or more impressed whether the threat is investor to state or normal legal action. You see the number of cases in the US against the government, or the government against the investors, by the way, if you look at the whole area of tobacco. I think there are, legal risks are there, independent of the systems. And I don't think this is something, if it happens, which is particular to one particular way of dealing with a conflict. Now, second point, the investment court. And I think here we got a bit more credit, if I can call it that. The investment court system addresses, in our view, a lot of the criticism. We have, for the first time, really moved away from what was called private arbitration. And by that, of course, some critics meant, that you choose your investor because you think he will do what you want him to do. Government chooses the other one, and then you take your chances. Here we have, like in most domestic systems, you have a predetermined number of people. They will randomly take a case. There's no way that anyone can influence the system. And I think that we hit the right balance here is actually shown by the fact that we got quite a lot of criticism for that proposal, not from you in the room, at least most of them, but from the other side, from the business side. They say, we're not so sure that this is a good solution. So if they are having doubts, and the American business being the first to have doubts, so maybe that is the right balance for such a system. And we have cut the link between a case and the arbitrator. We have also cut the link on the financial questions. And there, I think, again, I'm not really sure whether that system is so much different from other international courts. WTO arbitrators get paid per diem when they are actually asked. Appellate body judges have a retainer, so they are available. International courts usually work that way because you cannot employ these people full-time. That would be a waste of energy or also, I think, human capital. But you have to cut the link, and you have to make sure these people are independent. And this is exactly what we try to do. And we have actually expanded, and this maybe you haven't seen this yet because it's just out an hour ago. I think the witness issue, the question that you cannot be a witness, and the question that you cannot be, what was the other point, an arbitrator in another case. I mean, we strengthened that rule even more to what was out 2 months ago. So I think the ethical issue is very much on our mind. It has to be, because this is where the trust of the public, party-appointed expert or witness are no longer possible, where the trust of the public is important. You cannot, and this is why we took this step against a lot of resistance also internally, many discussions also with our member states. You cannot really claim that you're moving into a system which is fully independent as long as you have people choosing who's actually going to sit there in the end. I think that's a real step forward. It's a major step forward, and I hope that this is, again, something which will convince our critics, and some of you in the room even, that this is actually a real departure and a step forward. I mean, ultimately, and this is, as mentioned, it hasn't been mentioned yet today, ultimately our objective is, and this is also in our text, is to have a fully functional multilateral court as we have in the WTO, or as we have in the law of the sea, or as we have for human rights. And there, in these instances, also I think the criticism that there's a parallel justice there, or some people actually do interpret international law because we're talking about international law obligations of treaties, not about domestic law. That you don't hear. Everybody thinks it's perfectly okay that these judges talk about human rights, although we all have wonderful human rights clauses in the European Charter, in the national constitutions, etc. But that's not the point. Your national court will do the interpretation of the constitutional law. The international courts on human rights do the international conventions interpretation. Usually that is more or less the same thing, but not always. And you have actually lots of cases going up which have been decided differently on the local level. Everybody can live with that, so why not accept that if you talk about international law, an international court makes a lot of sense. And it doesn't take away anything from the domestic system, because the domestic system rules on national law. The domestic system will never rule on TTIP, what we put in TTIP or whatever it is. So I think that's an important difference to clarify. And that is not such an anomaly, if I may say so. And also when you think how much money is involved, I mean, the cases, the domestic cases easily go into billions as well. And most of the ISDS or ISC as SCS cases now don't go into that level of cost or of damages. But there is an issue. I mean, we have to discuss the point that was made, how much damages, profit, etc. are part of the definition of damage is one of the things we grapple in our negotiations with. So we're quite aware of this particular point. The last point, if I may, because I don't want to monopolize the debate, and you can speak on these things for a long time, but I think it is really important that I also say something about the question of local as I started to already do right now, about the question, is there a blanket rejection of domestic proceedings? I think I've partly answered the question. Domestic proceedings are actually about different things. They are about domestic law obligations, not about international investment or free trade agreements. So the subject matter is different from the start. But I'd also like to say, since the issue at the heart of this can be the same, the important point is that our system doesn't discourage the domestic avenue. We're actually, and this is, I think, a misunderstanding. There is a different system where you say, which is called the fork of the road, where you say you have to make up your mind, either you go domestically or you go international arbitration. Then I think the danger is very big that people will say, before I take the risk of going to a domestic court, I'd rather go into international arbitration. And some of the investment treaties out there have that. What we are trying to say is, you can go to domestic courts, and that's probably cheaper and maybe sometimes quicker. But once you go there, you can't do the other things. We don't want parallel proceedings. And if you start international arbitration, there's no way you can go back to domestic courts. So what we actually think will happen is that people will try and see whether they get a fair deal in a domestic court. But in some jurisdictions, people will not even try. I can be very clear. There are some parts of the world where you will not try. So I think we leave a choice here, but certainly I think in our parts of the world, there will be an incentive, or at least no disincentive, to use the national courts. Also, as I said, the objective is different. If you go to the national court, you can ask for a measure to be repealed, which you can never do under the investment court system. I think this will also come into play. It's not just a question, where do you go, but also what is your final objective. The question that also, Claire, you've asked, what is the public interest in all of this? I think there is another important point to make. The public interest in this is to have the right balance between our right to regulate, which we are trying to do much better in our new approach, but also to have a minimum protection of the money that our operators spend elsewhere in the world. And I will tell you why. And this is not something which is ultimately different between a country where you're not so sure whether you get your legal protection and maybe the United States and Canada. The basic reason is that even in very well developed legal systems, you can never exclude something like national bias. This is, I think, something which you can see in procurement contracts. We were trying to have a level playing field in the EU and worldwide. But you can also see in cases of big accidents, you wonder, if something happens and a foreign company is involved, whether the same reaction will happen to a national company. That is basic psychology, and it's basically a fact that it's it's not so easy in all cases to avoid that. I'm not saying it's the rule, but I'm saying the danger of that is there, and it depends a little bit on which jurisdiction you're in. But there is an interest, and what we are getting for the public, our public interest is that protection. We are giving this particular avenue in Europe or in the member states who've done this for a very long time, and the trade-off is that we have the same rights for an independent system of court or arbitration, whatever you want to call it, elsewhere in the world. That's the trade-off. So the comparison is not so much what do you do with national companies, but what is it worth, let's put it like this, is it worth having this system in a country where Argentina, where companies have had problems and have actually managed to get a couple of billion back from some of the investments in expropriation cases? Is it worth having that in other parts of the world? Or is it not? That is the basic question. And then if we do this, we have to be consistent and offer it at home. And that, as I said, I don't think the new system will be a major burden for us, despite the concerns that many have in that respect. That is, I think, the basic answer. We are the biggest, and I have to repeat that again. I mean, a lot of jobs in Europe depend on having a functioning outward investment system. And it's not just big companies, and this is my last point, it's also small companies who will maybe not take a case in a very costly system like the US. If you go to court in the US, you have to be very careful whether your purse is full enough. I would even say with the new rules, and I'll say this is my last point on the SME chapter in our proposal, it's probably going to be cheaper to use that if you really have a problem with, let's say, a jury in Mississippi, which I think, or Alabama, where this case that you mentioned, Gus, comes from. The SME part of our proposal tries to address also the question of costs and some other issues. First of all, we have now a full-fledged system of mediation. Mediation means you don't really have to go for a full court, but you have you can try and attempt to mediate, which is of course much cheaper and much more accessible for a small company. You know how mediation works. It's not binding, but it does give at least a result that is useful and which actually can solve the dispute. Doesn't always be the case, but it can. We have the procedural deadlines. We actually have deadlines now which make it impossible to draw out a course until the small company is broke. That is usually sometimes a tactic governments have employed. So pretty tight deadlines for cases. You have the possibility to only have one arbitrator, because that or one judge, to use the new terminology, that makes things a lot cheaper. Apart from the losers pays principle, which I think was also mentioned in passing, we have also in the loser pays principle, we can have a limitation of the costs that have to be refunded. So I think, again, we're trying to tweak the system whether we can actually make this more user-friendly for small and medium enterprises, because like many of you, we don't want this to be a system for the behemoths who have very deep pockets, but we really wanted to work to protect those people who are taking a leap, also the smaller companies, and who have a lot of resources at stake in a particular case. And there are some cases like that where people went into Tajikistan, to name one example, or places which have a dubious, sometimes dubious record on enforcing the law or the international law. And there, I think that was quite beneficial. We can have a discussion about that, but I think that's what we're trying to achieve. So I'll stop here because I've been probably equally long as Gus in explaining all of this without a PowerPoint. But my basic point in the beginning, I would really like all of us to reflect whether this is not a basis that we can build on. It's not perfect, and we're never saying it's perfect, but it's from our internal debates, I think, a good balance of what we are trying to achieve as the biggest investor in the world, where a lot of our economy depends on having functioning global systems, as I said, and at the same time keeping the right to regulate. And that includes, by the way, final word, the right to regulate for the EU, for the Commission as proposing legislation, of course, for the Parliament and others. So we're not oblivious to that point, because the Commission is also behind a lot of regulation. So why would we do that if we think that regulation is at risk? Thank you.
First, I just wanted to make sure that we're all clear on a few of the points that both Gus and Rupert have discussed. So this one point about the right to regulate and the issue of investors being able to file claims in response to general regulation, which is part of your presentation, and you've also mentioned this. Now, Rupert, you mentioned two cases, Vattenfall and Philip Morris, because these have clearly been in the public eye. Are these cases that you don't think could possibly go to the investment court system because they would just simply not be allowed in? Or how exactly does this reform proposal protect citizens against cases like that? And I don't know if you could respond very quickly to that, just so that we're all clear. And Gus, if there's anything you wanted to come back on that as well.
Yeah, I mean, it's always difficult to answer a hypothetical question, but I think the protection for health policies that is in the new proposal, and also for environmental policies, is mild stronger in our proposal than it is in the Energy Charter Treaty for this matter, or the Hong Kong-Australia Bilateral Investment Treaty, which doesn't have anything like a right to regulate carve-out.
Well, those claims would certainly still be possible. And I agree that there's always a speculative assessment on how likely they would be to succeed. if I compare the most recent text, actually from this morning, which I did kind of read the operative parts on the way over, to the one, in the last month or so, to the other main text we have, which is the CETA, there are some things in this proposal that make those kinds of claims less likely to succeed, but there are other things in this proposal that make it relatively more likely to succeed. Now, that's a very general comment. For example, the umbrella clause. There's no umbrella clause in the CETA. And if I can maybe address the clause that makes it less likely to succeed, which I think is being overrated, that's the statement on the right to regulate. So I actually have it on a slide. If you go to slide 4, we can all take a look at it. As I mentioned earlier, if there was a simple, clear, reliable statement of the right to regulate in this text, I would be cheering. But I always look for the lurking bit that makes me say, oh no, they did it again. Right? They just gaveth with one hand and they tooketh away with the other. So if you go to slide 4, I'll show you what that is. The main thing is the necessity test. Here's the clause: the provisions of this section shall not there we go, thank you. Shall not affect the right of the parties to regulate within their territories through measures necessary. Okay, the necessity test is notorious for those who have read the ISDS awards, because arbitrators have interpreted that language very strictly to say you can only rely on the relevant carve-out if the measure you adopted was one that had the least impact on the foreign investor, or if you did not in some way contribute to the problem. So Argentina tried to rely on probably the most analogous situation is Argentinian cases where Argentina tried to argue as a defense that the essential security exception under the U.S.-Argentina BIT excused the emergency measures it adopted in the context of a financial and economic crisis in the early 2000s, and lost in all but one of the 4 or 5 cases that dealt with that issue, based on strict interpretations of the concept of necessity. To say the Argentinian emergency measures, they could have adopted different measures. They could have chosen not to depeg from the US dollar and so on. That would have had less impact on the foreign investors. Or there was something that Argentina had done in its earlier policies that contributed to the crisis and therefore meant that the response it chose wasn't technically necessary. So that to me is a very strict approach to the necessity test. It's not the approach I would take. I assume it's not the approach Mr. Schlegelmilch or any responsible public official would want to be taken. The trouble I have is that we have a clear record of ISDS decision making that on balance adopts a strict approach to the necessity test that causes that word necessary to set off a kind of ringing alarm bell when I read that clause. And I can compare it to other language. For example, it also says shall not affect the right of the parties. Well, does a monetary award affect the right of the parties to regulate? It's kind of a difficult question to answer because, in fact, promoters of ISDS often say, your regulations can still be passed, you just have to pay damages. Well, I can see that clause being interpreted in the same way, and that worries me when I compare it to the next slide. The next slide after that. Okay, so this is an example of better language from the same proposal. It's an earlier part of the proposal, market access, performance requirements. This title, or it could read, this chapter shall not apply to measures affecting, and then lay out the concerns you have on the right to regulate: health, regulation, labor standards, consumer protection, all kinds of things that would be captured by that idea. That's language that the Commission is aware of. It's much stronger language. But in the right to regulate, in English, I don't mean to be insulting, but we would use the term weasel language, okay? Lawyerly language that takes away what appears to be given to the uninitiated. And frankly, that's what motivates me to talk to people about this, because I know it's easy for a policymaker or a journalist or a member of the public to be fooled by that kind of language without looking at the detailed legal text with a knowledge of how those words have been interpreted and applied in the many, many awards by ISDS arbitrators. Well, I want to say again, this isn't the old model of ISDS, and I understand people like Mr. Schlegelmilch have to make difficult choices, decision makers have to make difficult choices, and so on, and I want to acknowledge that. I am an academic, and I have the luxury of operating from a position of principle. I mean, not to be too complimentary, but I don't have to get involved in, you know, all the political compromises, so I recognize that. But I try to think about that when I react to these kinds of texts. And when I look at the details, and it's in the details where my enthusiasm diminishes. So, for example, on this point, it's a very important point in my view on ethics, because it goes to the heart of the public concern about the lack of independence in ISDS, is the conflicts of interest of arbitrators, which are rampant. At least apparent conflicts of interest are rampant in ISDS. One of the reasons is because the arbitrators are appointed by one side in a proceeding, they work on the side in different roles. So I mentioned how the so-called judges in the Commission's proposal are not precluded from working on the side as arbitrators. And I have the language from this morning, and it's the same language on this point. It says, in addition, on appointment, they, the judges, so-called judges, shall refrain from acting as counsel in any pending or new investment protection dispute under this or any other agreement or domestic law. It says counsel. I happen to have seen another version of this document, which I understand is an internal version, that had a longer list than simply counsel. It could include witness, it could include expert, it could and should, most importantly, include arbitrator. Because you can have a situation where someone on the list publicly chosen is allowed to work on the side as an ISDS arbitrator, be paid vastly more, be appointed by foreign investors and paid vastly more. And that clearly is inconsistent with the idea of an independent court. Linked to this point is the issue of remuneration. And I acknowledge there are other international tribunals where payment is both a set salary with a top-up for the daily work. But here, the concern I have is the top-up is far too rich. From my estimate, it's about 5 times the daily rate at the World Trade Organization. And to me, that's a troubling nod to the existing forces at play in the ISDS legal industry.
Great.
On the second question, on the question of the text on what these are, what the judges can do, and I hope we're talking about the same wording, because now we have refrain from acting as counsel, or as party-appointed expert, or witness in any pending new investment protection debate. Huh? The arbitrator word is missing. You can be maybe an arbitrator twice, but this is what I tried to point out. It is really 1 hour or 2 hours old. It was one of to be fully transparent, as the Commission always is. This is one of the last changes in our internal debate. Well, I mean, no, but this
And
came.
you don't have to do, that is then the version that somehow I got some weeks ago.
Yeah.
I saw that language. So, but still, the key point is arbitrators should be on that list.
Okay, but again, I think you will be with me when I say some of the concerns have been addressed. Expert, witness. We don't. Well, I'm not going to put any word in your mouth. That's fine. I think the point is, of course, if you also exclude them to be arbitrators, there are not that many, or judges. I'm not sure how many judges we will find for all our bilateral treaties. So maybe some people will have to be judges in 2 of these systems. I don't know. But again, this is the fine-tuning. We're happy to discuss that, and I'm thinking also in the negotiations with the United States, we will have an animated debate about these things. The same is true of the question of costs. We had a long discussion and asked ourselves, what is the right level of costs? I think the debate is wide open on this. We don't want to overpay anyone, believe me. I have to go to DG Budget, which is one of the worst things that can happen to an EU official, to go to DG Budget and ask for money for something like this. What? so I think we also try to keep the costs down, I can assure you. On the other hand, this system in the WTO or in ICSID is a little bit what we're looking at. ICSID is the International Court for the Settlement of Investment Disputes, which is the leading, one of the leading, not a court, mechanisms available, if I can call it that, how to run what is under their terms an arbitration. But there, I think we have to have a comparative. But we are quite happy to talk about how much money that should be. I mean, I don't have a fixed religion on that.
Let's take the first two together. I guess the first two questions from the first gentleman, the fair and equitable treatment clause, and what happens with all of these other treaties that are being negotiated at the same time. Does the FET clause go into those as well, or any of these other? I mean, that's a good question. Any of these other reforms, how do these get incorporated into the bilateral investment treaties the EU is negotiating now? Into what happens with discrepancy between TTIP and CETA? Is this like a parallel system? Sorry to add to that question. Go ahead. Do you want to start? Okay.
So the fair and equitable treatment standard is the most dangerous standard for anyone concerned about the right to regulate and from a government point of view, because it's been used and, in my view, frankly abused by arbitrators, let alone counsel for foreign investors, be interpreted in a very broad way. The role of that standard customarily was like a last resort clause. If you hadn't suffered from discrimination or a direct expropriation or some indirect expropriation that was in effect an expropriation, kind of disguised expropriation, if none of the other standards were violated, you had this minimum standard of treatment to protect against really egregious forms of abuse. And the arbitrators turned that into a general power to review laws, regulations, changes to laws and regulations. They introduced new doctrines of legitimate expectations, just read them into the standard. That's a big part of the story of how ISDS arbitrators themselves exploded this system. That is, were responsible for the explosion of claims by taking textual language that the negotiators, at least the NAFTA governments, consistently maintained was this last resort standard. The European Commission has gone beyond the position of the NAFTA governments in the proposal this morning and in the proposal a few weeks ago and in the CETA text. Okay. There's really no significant variation. I can go into the details, but I'd have to steal another half hour. Essentially what it's done is I would say it's met the arbitrators halfway. It's used, again, qualified language to remove this duty to maintain a stable regulatory framework. It's still not clear language, which I find troubling. It's integrated the new doctrine of legitimate expectations, which may exist in some legal systems, but is implemented in very different ways to an ISDS, and it's used that as a reference point for interpreting a list it describes as closed, but again, there's not clear language to mark it as a closed list. So again, I don't want to get drawn too much into the details. I just want to say that if we compare the European Commission's proposals to this day to the position the NAFTA governments have taken consistently since the beginning of the NAFTA explosion of ISDS, the European Commission has moved in favor of the foreign investors' point of view and in favor of the many hawkish arbitrators who took fair and equitable treatment beyond its customary last resort meaning.
Okay, on this point, I have to disagree. First of all, we don't meet arbitrators' requests. We try to do what is good for the public and for our investment, our legal systems. But more to the point, I mean, I agree that the old fair and equitable treatment was a very, very dangerous concept, because you said we will treat investors fair and equitable, full stop. And then you went off, and if you had a case, the arbitrators could do whatever they want. But that's a far cry from what we have, or a very, very different concept what we have in our text. where we actually say there is a closed list of issues, which is the usual denial of justice, I mean really arbitrary harassment, etc. You can really see what we mean by FET. And I think, in my view, that's even better than what you have in NAFTA, because in NAFTA you refer to some sort of minimum treatment of standard or customer international law concept that nobody knows what it is either. I think you have to be precise, and this is exactly what we try to do. If you read the list in Article 3, Paragraph 2, for those who want to do some homework, or read it up, or want to read it up, it really says there is a number of things which are very clear, defined. So the arbitrators cannot stray and do whatever they like. So, I mean, basic disagreement here. The point is, of course, if you denial of justice, if you don't cover these things, that will, then I think we're not protecting, we're not doing what we should do. If you can't even go to court, if you don't even have access to justice in another jurisdiction, or if you are target discriminatory, for example, because of race or religious belief, which is the sort of thing we set out here, I think we have a case to put that in. You know, you have to be able to fight these things, and that's why we put them in. But we don't want a free for all, which I think would be the sort of danger that has been alluded to. And then the questions which came after that from Mr. Fuchs and others. It's clear that what we're doing here is presenting a proposal for the TTIP negotiation, but it's also clear that this is what we basically think the reform of the system should look like. Meaning that this will be the inspiration, and the integrity of these proposals will be proposed in other negotiations. Ongoing negotiations, we have already alerted some of our partners where we are in the middle of a negotiation that they have to look at this. Japan being a case in point, for example, where we're halfway in a free trade agreement with an investment part. It's a slightly more complex, the other question on Canada, where we have a closed text. But we've also been very clear, we don't think it's useful to reopen this very complex agreement. But on the other hand, we see the necessity to see what can be done on some of these points with the Canadians as part of the legal revisions, where we can still adjust things. And where we're going to come out of that depends not so much on us, it also depends on the new government in Canada, which hasn't come back to us yet. But of course, our Canadian friends are aware of what is happening here, they can see the text, etc., etc. So that debate will take place.
The first question being, we have all these unreformed ISDS provisions in other treaties. So, if we don't have a reformed version of ISDS, all we have is old ISDS. So, how do you respond to that argument?
So I'll try to keep it brief. ISDS is a deeply flawed system. It's not fair in its process. It's not judicially independent. It is far from balanced. And it still is all of those things despite steps taken by the European Commission. And my answer is fix that problem. Either make ISDS fair, independent, balanced, respectful of domestic institutions, including domestic courts, unless the foreign investor can show why it's not fair to go to domestic courts. That's not unreasonable to expect. It's expected of everyone else. Foreign investors, the biggest multinationals in the world, are more able than anyone else to make that case. And they should have to make that case. And until it's made fair, independent, balanced, and respectful of domestic institutions in that way, it doesn't belong in any treaty. So take the treaties where it exists and get it out, or replace it. And if you can't replace it because the other side won't cooperate, then terminate that treaty, which is your right under the vast majority of existing treaties, bilateral investment treaties, and it will not be possible under multilateral trade agreements. It will be theoretically possible, but practically impossible. So whatever you do, don't put it in to new treaties, especially new treaties that are relatively immutable, and certainly don't put it in if it continues to not meet the basic criteria of fairness, independence, respect for domestic institutions, and balance. Okay? And by balance, I want to stress that's Foreign investors should not have extraordinarily powerful rights and protections without any actionable responsibilities, even in the most modest sense of allowing a counterclaim by the state or third parties against the foreign investor in response to the allegations made in the initial claim.
Before I come to famous last words, I mean, there was this question on the EU legal systems, and I guess we wouldn't disagree. I think it's one of the tasks that we really have to continue to work on. We, of course, the Commission and the national governments and the EU as such is working on this to improve the legal situation in some of our jurisdictions. That's not a secret. You can read it in the progress in some of the reports, etc. It's not easy, but it will remain as more important than maybe more important than what we're doing here. Very clearly, the EU legal order has to be functioning, and where there are deficiencies, we should really go after that. My only other point is, you know, I respect the academic view, but I think the reality is that's not going to happen. I mean, you know, the world will keep on doing these treaties, and I just mentioned the Trans-Pacific Partnership Agreement, which just was concluded, and there are 12 countries who said yes to this sort of system. So let's, what I think is realpolitik is called for, and realpolitik is what we are trying to do. I think the system is actually fair, and I think the system is balanced, and the system is certainly, and even maybe you can agree at that, it's a lot better than it was. And this is the way politics are made. And if you disagree on that, I think then we have a basic disagreement which we'll not be able to solve. But in the circumstances that we are in, we've done our best to have a system which is independent, where ethics reign and not just anybody's interest, and where we can show that this is pretty much like other international arbitration, be it in the WTO, be it in the International Court of Justice or the Court of the Sea. That's what we want to go. And that will certainly, in my view, address many of the issues, and it will be, I think, the only way forward if we are trying to achieve something of an improvement in the situation that we have today. But I respect the views of others, of course. If that's not the view here, we'll have to live with that. We're going to try to, and would like your support, because if we don't, as I said, if we don't get it, at least some more support, because if this doesn't go anywhere, I think the situation will not change by just asking for everything to be sort of terminated. It's not going to happen.